All right. Hello, everybody. My name is Tiela Chalmers. I'm the CEO of the Alameda County Bar and Legal Access Alameda. And I have the distinct pleasure today to be speaking with Leslie F. Levy of Levy VINICK. And we're going to hear about her practice and some of what she's been up to. So Leslie, thank you, first of all, for joining us.
Certainly. Thank you for inviting me.
And maybe you can just start by telling us a little bit about yourself. Where did you grow up? Did you always know you wanted to be a lawyer? That sort of thing.
So if I talk long enough, you'll realize that I grew up in New York, even though that was now 50 years ago, actually in the South Bronx, not far from where Justice Sotomayor grew up.
Mm-hmm.
And no, in fact, for many, many, many years, I did not want to be a lawyer. I went to UC Berkeley and ended up with a degree in philosophy, which leaves you, on one hand, almost no options, on the other hand, every option, because there's not much to do with it. I spent some time working in political issues. At that time, I became the chair of the East Bay Coalition Against the Briggs Initiative, which was the anti-gay teacher initiative. And the truth is, I kind of went to law school out of a lack of other choices. And when I went to law school now 38 years ago, I had decided I would practice law for 5 years and then go do something else. Didn't work out so much.
Where did you go to law school?
Went to law school at Hastings and graduated in '82, right around the time of the White Night riots, the shooting at City Hall. And I spent a good chunk of law school, for better or worse, not spending much time in law school and working on various political issues, including organizing the Take Back the Night March, the first Jewish feminist conference, and other demonstrations and issues that were up at the time.
You know, I think we should mention for people listening to this who may be somewhat younger that in the 1980s, you could think of going to Hastings and then doing something else because tuition was a whole different level than it is today.
Absolutely true.
Yeah. So there you were in law school, you were politically engaged. Did you have a sense of what area of law you wanted to practice?
No, not specifically. I knew I wanted to do some sort of progressive type of law. I had some interest in the public defender's office within limits, because there were certain cases that I could not see myself defending if I thought the person was in fact guilty, such as domestic violence or sexual assault cases. So I wasn't sure how that would get navigated if I got into the public defender's office. And I identified very strongly as a lesbian feminist. I wanted to do work in some sort of civil rights law.
Okay, and so how did that come out? You graduated from law school.
Well, it actually started in law school. I was looking for a summer job and I was in an elevator, I think at Berkeley Law, I'm not sure. And I started talking to this guy in the elevator and about civil rights stuff. And he said, "Did you ever think of disability rights as a civil rights movement?" And I looked at him and I said, "No, but it makes sense." And it turned out that I was talking to the then director of Disability Rights Education and Defense Fund. And I ended up working there doing disability rights work, which influenced me a great deal when I graduated law school.
And how did it influence you? Did you go into that area at first, or?
Well, when I graduated law school, I actually set up my own shingle. And that was really only possible because my partner at that time, who was still my partner, had been a legal secretary. So she actually knew how to file papers. She knew where the courthouse was. all the things they don't teach you in law school or didn't then. So with her help, I was actually able to hang out my own shingle. And one of the first cases I took was on behalf of two blind women who had fallen onto the BART tracks. And they had been to a lot of lawyers who wanted to take it as a personal injury case, but they wanted it as a civil rights case because they wanted it to be changed. And so, somewhat out of naivete, I looked through the law and I thought, well, equal access means equally safe access. And so we went to court and asked for injunctive relief for BART to install the edge detection along the tracks, which is what everybody sees now everywhere. Those little bumpy panels, they let people who are blind or low-sighted know that they're about to cross over into something dangerous. And we won. The court ordered them to test edge detection and, if successful, put it in. So that was one foray. And then at the same time, I was suing BART. I don't know why they became my target so much, but for independent access for people who needed elevator use. So BART had never intended to put in elevators. So they went to weird places and you were dependent on a station agent, and they were advertising how it was going to be a system without station agents. And ultimately, we sued them to put independent card readers at all elevators to allow access without being dependent upon the station agent. Wow. So that was the first probably 2 years of my practice.
With suing BART, it sounds like, for disability access. Wow. That was a brave thing to open up your own practice right out of law school.
It was scary. It was a little crazy. I kept my overhead incredibly low. I just had a one-room office. I think now, in some ways, it's a little easier because of all the remote access that you really can keep your overhead down. So.
So how long? It looks to me like you essentially stayed in practice on your own for pretty much the balance of your career.
Most of my career, I was either in a solo practice or a partnership of some sort, with the exception of about, I'm not even sure, you can look at my CV, about 5 or more years I was at Boxer and Gerson, which is primarily a workers' comp firm, but I and Jean HYAMS and Darcy BURRELL made up their employment discrimination section of their practice. But other than that, I've always been in my own practice in one form or another.
How was that to go into a firm after being on your own for so long?
It was a little odd, except that one of the reasons I accepted doing it is that the employment section of the firm was quite independent. We ran our own cases. I knew Jean for many decades. We brought Darcy on. So we had a lot of kind of independence within the firm.
And then you went back, and now tell us a little bit about your current firm.
Well, right now, for the last, I believe, close to 11 years now, I've been part of the firm Levy, VINICK, BURRELL, HYAMS, which consists of 6 women lawyers and support staff. We specialize in employment law, although that's not something I've always specialized in. We represent only plaintiffs in all sorts of employment. So whistleblower, discrimination, harassment, retaliation cases. We do some class action cases. We do some wage and hour work. Pretty much anything in the realm of employment, the office does. I also do sexual harassment cases in education, in housing, and other abusive power type relationships. After I had done all the disability work, while I still did a little of that, I actually moved into sexual harassment as an area of law, which is different than what most people do. Most lawyers will do employment, or they'll do, education or housing or something. And my interest was in dealing with sexual harassment and assault wherever it occurred. So I took that issue and followed it into the many kind of categories that lawyers work in, and brought one of the first multi-plaintiff sexual harassment and housing cases in the country, against a company called Fairfield North, where a manager was sexually harassing multiple tenants. And we worked with the Department of Justice and started a whole chain reaction of all the fair housing agencies finally dealing with this issue and putting out literature and training people, and HUD getting trained and DFEH getting trained. So I followed that, and I still do sexual harassment in housing and in education.
And maybe not speaking right now, but in the past, how did your clients find you? How did you find them?
I thought they were mostly nice. No,
Very nice.
One of the critical things, I think, was my community involvement. Mm-hmm. So I think having been involved in political groups, having been involved in community groups, having worked for Disability Rights Education and Defense Fund, that created a whole network of people who found me, particularly around civil rights issues. Mm-hmm. And believe it or not, this was before the internet. And I think since then, all sorts of ways. I mean, just kind of being visible on particular issues that are of interest to you makes a huge difference in terms of people contacting you and finding you.
Getting your name out there. Talk to us about some of the legal focused organizations you've been a part of. I know you've been very involved in Women Lawyers of Alameda County for many years. What about that group and other groups? What role has that played in your career, in your development?
Well, I am honored to be the president of Women Lawyers of Alameda County after having served on the board for a number of years. I think it's played an important role, and I'm not sure if it's been an important role in terms of getting cases, but it's been an important role in terms of colleagues and information and enhancing my ability to practice well. So being able to network among other lawyers about information, about judges, about cases, about other resources. And I have loved the collegiality in Women Lawyers of Alameda County. I've found ACBA to also be helpful in terms of being able to contact colleagues. And while most of my contact, like in California Employment Lawyers Association, is with colleagues who do what I do, ACBA, WLAC, and some of the other organizations like SFTLA also help in terms of contacting lawyers who may be doing something somewhat different in different areas where there's overlap. And occasionally there are referrals, but that's not those organizations aren't a primary source of referrals, but they are a very important source of information and contacts.
And is your firm now all women?
We have one staff member who is a man, but the lawyers are all women and most of the support staff are.
And is that an important thing to you?
It has been. We are very, I think there's a certain kind of collegial atmosphere, and, as women in law, we spend a fair amount of time dealing with the sexism in the profession, be it from the bench, be it from other lawyers, be it from clients. And it is a relief not to spend time having to deal with that within our own office, and finding that that's just a non-issue. and also having a safe place in which we can discuss those issues as they come up in our practice.
And are you finding that things have changed for you as a woman lawyer over the time of your practice, or you feel like we still have a long way to go?
I would say both. I think we have a long way to go. I do think some things have changed. I think, when I walk into a courtroom, unless it's a federal court, and there are many women who are present in that courtroom. I find that women are not that present in federal court, and there are still relatively few numbers of women who consider themselves trial lawyers. I think women, when I first started, it was a fairly radical thing for women to wear pants in the courtroom. Although I have to say, I haven't owned a dress since I was about 12. And what is a little concerning to me is it's now becoming unusual for women to wear pants in the courtroom again, which is not a statement against women wearing dresses if that's what they're comfortable with, but it is becoming, I see, the more dominant dress, and I think it's becoming less usual for women to be comfortable in pants in a courtroom. While that may seem minor, I don't think it's as minor as it sounds, because I think it has to do with comfort, it has to do with how you're presenting yourself, etc. But I think that what's most important is that I think women are learning that they need to find their voice in the courtroom, not just imitating their the male partner or what's expected from them by those partners. I think that they're learning that the best lawyering they can do is when they find a voice that's authentic to them. And I think that's changing the kinds of voices that are acceptable in the courtroom. I still think that race and gender, and for women of color, it's a double hit in the courtroom. There's still countless stories about women being, where judges think women are the court reporter or the client, or in deposition, same kind of thing happens. It happens less, but it still happens.
Let's talk about some of your favorite cases that you've had over the years. I will say that when I just started at Alameda, it was right after you had, or maybe right at the same time when you had the Oakland Raiders case, which certainly got a lot of headlines. I don't know if you're able to say anything about that. You can at least explain what it is.
Well, the first thing I have to do is I have to give credit mainly to Darcy and BURRELL and Sharon VINICK, who primarily litigated the case. And it came in, interestingly enough, from a defense lawyer who knew the cheerleader. And she came into our office with her contract from the Oakland Raiders. And we read through this contract and it was like, no, this can't be real, because in the contract were explicitly illegal clauses, statements about work that they were not going to get paid for. And ultimately, when we read through it, we realized that these women were basically getting paid significantly below minimum wage when you put together the hours that they worked, as well as being subjected to very, I would say, outdated and clearly sexist provisions. We brought a class action. It was controversial because the women cheerleaders had all been basically threatened and said, if you stand up against this contract, you won't have a job, and look, there's hundreds behind you just waiting for this opportunity. We did it anyway, and it started a pattern across the country where somebody from the Buffalo Bills, a cheerleader there, sued cheerleaders in Chicago, in Florida, and in a number of other states. In Texas took up the same banner. And in the case here, we settled it. The women were paid for their hours as far back as the law would allow. And the Raiders changed their policy going forward. Not as much as I'd want them to change, because they now pay, I believe, just minimum wage or maybe slightly over it, even though what the women are doing on that field is serious work, and it's hard and it's straining, and it's limited in terms of how long physically you're able to do it. And they pay their mascots multiple times more than they pay their cheerleaders. So while we weren't able to deal with that issue in the law, we were able to get them appropriately compensated. Interestingly enough, a documentary was made about them, and
Really?
about the case, about the Raiders and the Bills, and it's called A Woman's Work. It's actually a shorter version, is previewing on PBS on January 4th.
Wow.
They call it the documentary the NFL didn't want you to see. And in the longer version, which will be released later that month, our firm is actually interviewed in it. So it was exciting. It was fun. It was, I'm really happy we did it. And I'm glad that it changed. Not as much as we would want, but the law has limits as to how much it can do.
Right. And has that contract been changed throughout the NFL, or does it depend on whether there was a case brought?
I don't know. I know it's been changed in many, many states or many, many teams. I don't know which ones. I know that what the Buffalo Bills did was they disbanded their cheerleaders rather than pay them. So, and the NFL was saying, oh, we have nothing to do with this, when in fact they did, because they actually signed off on many of these contracts, although not on the Raiders one.
So it seems like it's really an ongoing issue to some degree.
Yeah, although how much of an issue in COVID, I don't know.
Yes, right. That's a whole different story. All right. Are there other cases that you look back on fondly?
Yeah, the sexual harassment in housing case that I did is really a very important case to me. The clients were fabulous. I think there were 12 women and their kids. They were mostly on Section 8 housing. The manager was horrendous. And what was interesting is they went to several lawyers. They went to their state representatives, and they were repeatedly told that there was no law prohibiting him from sexually harassing them. And the reason that the case was really instructive in this way, because what was happening was they were going to housing lawyers who were looking at the statute that said prohibited sex discrimination, but didn't say a word about sexual harassment. And even though those, the law had been expanded in employment and other areas to define sex discrimination as including sexual harassment, but housing hadn't caught up. And so I knew the definition of sexual harassment being a kind of sex discrimination from the other work I had done. And so our position was, that's what the housing laws are concerned about too, even though it's not explicit. And so we were able to involve the Department of Justice. We were able to move the whole issue forward. The women got significant settlements that changed their lives. They started an organization to help other women address it. They appeared on Oprah. It was like a major change. And their kids had not huge, but some trust accounts set up for them, which changed their lives as they turned 18. It was very touching, and it felt like it actually moved the issue forward on a national scale. And it's my understanding now that DOJ regularly takes sexual harassment in housing cases.
Huh. That's that interesting dynamic, right? Where things often have to start really at the grassroots in order to percolate up. We often wait for that kind of a change in the law to percolate down, but that's often not the way it works.
I actually have always felt that the law, that social change comes from the ground up, and that the law and lawyers can try to codify that change. But if there isn't a grassroots movement, if it's not coming from the ground up, it's not going to really change in a meaningful way
Right.
that sticks.
And now some people would say now that we shouldn't be looking at the courts in that same way that we used to as the place where progressive change will be made. Do you think that same thing is true of the ground up pushing the legislative branch or executive branch? It's hard to say where we would look, but
I think a lot depends on where you are geographically. I mean, you can say California's in a bubble, but in some ways it is. But I think we underestimate how much progressive politics there actually exists throughout the country. Um, in part, I think the spin doctors on the more conservative side have done a really good job of kind of making us think that that's the majority view, when in fact, we know it isn't. We know that, for instance, reproductive rights are supported by the majority of people in this country. But you would never know that if you listen to the Senate Republicans. So, but I do think that California has some pretty amazing progressive politicians. And so I think looking at legislative change in California is still a viable option for moving progressive matters forward. In fact, many years ago, I was one of the people who helped to author Civil Code Section 51.9, which is about sexual harassment in places other than employment. And recently it was amended to be made better and stronger and broader. So, and a lot of that credit goes to the Me Too movement, which did not start from the top.
right. Right. It's a really good example of that, actually. As potentially as the Black Lives Matter movement, right? Another grassroots movement that really swept upwards.
Right, and making the legislators pay attention to issues of race in a manner that most of them had not.
Well, Leslie, I wonder if you have any words of advice for newer lawyers starting out, particularly for women lawyers.
Well, I have a couple of things that I often say to all new lawyers. One is, before you get up and argue a position, think about whether you want to live in a world in which that position is adopted. In terms of, particularly if you're in an appellate level or higher, but even in a trial court level, do you really want to argue X? Because if X becomes the dominant law, is that the world you want to live in? So that's one thing I suggest. The other thing is for new lawyers to remember that in general, you're going to be hyper careful your first few years because you don't know. So you look up the statute of limitations 3 or 4 or 5 times in one case to make sure you don't miss it. But what you also need to accept is you're probably the most creative at that point in time, because you don't have a bank of already existing pleadings that you just cut and paste and dump. And that when you see something that in your gut tells you it's wrong, try to find a right. And I think the longer you practice law, the harder it is to think about being creative about that, because you feel like you know what the law will do or can do or has done. And I think when you're new, you don't it's easier to not be locked in. And I think you get more creative. And I think that's what happened to me in my BART case. Nobody had defined equal access as meaning equal safe access. And for women lawyers, I say, find your voice, speak up, surround yourself with people who are going to support you. I was about to say, don't be afraid, but a well-known criminal defense lawyer I asked one day, when do you reach a point where you're not afraid when you go into trial? And she said, you never do. The fact is, you will be afraid and you do it anyway. And so, you know, accept the fear, because in fact, when you walk in that courtroom, you are not in control. And do it anyway. And I would also suggest that I would also say that women need to push the envelope within their own practice, particularly if they're in a firm. I've now been part of like 3 jury trials in which there was a woman, the main defense counsel was a man, there was a woman sitting next to him, some cases a partner, some cases an experienced lawyer, not a partner. And she said almost nothing in that case. And in fact, when she did, she was better than the guy who was sitting there. And so push the envelope. You can do it. You can be the lead. You know what you're doing. You're gonna, you know, just do it. And talk to other women. Go to trainings that are aimed, particularly if you want to be a trial lawyer, try to find trainings that are aimed at women, because they're the ones who are going to try to help you find your authentic voice and to provide alternatives, alternative ways of being in the courtroom. I think that might be all.
That's some great advice. Leslie, thank you so much. I really appreciate your taking the time, and I look forward to seeing you at future events, whether it's in person or in a little box on the screen.
Thank you very much. And again, thank you for inviting me and giving me this time.
Of course.